Chapter 3 deals with the French cross-border insolvency position. Now, unlike the United Kingdom, there is no real depth to the case law in France, which enables us to see the principles by which judges will render assistance in the case of judgments or office holders emanating from another jurisdiction. Why is this the case? Well, the answer lies simply in the rules that are contained in the Civil Code, and particularly in Article 5, which prevents a judge deciding by what it calls generality. So a system of precedents and the fact that in a judicial hierarchy, inferior or lower courts will follow decisions made by superior or higher courts does not apply necessarily in France. The roots of this are, of course, historical and go back to the mistrust of judges that showed itself in the French Revolution and in its aftermath. What this means, though, is that French judges are uncomfortable deciding cases and making orders in respect of overseas companies and overseas debtors unless there are firm statutory rules that allow a judge to do so. There are two sets of statutory rules that apply in the context of a French insolvency. The first emanates from the rules of the insolvency law itself. Now, modern insolvency law is to be found in the Commercial Code, particularly in Book 6 of that code. And as with all other insolvency laws throughout the developed world, you will see that it contains both rescue and liquidation provisions. Now, the basis on which these procedures are applied to debtors depends on whether a French judge recognizes that the debtor's principal center of interests is within the jurisdiction of that court. And what this means is, using language very similar to the European Insolvency Regulation, that a state of incorporation doctrine such as that applied in the United Kingdom is merely a presumption guiding a judge to determining where a corporation is located for the purposes of asserting jurisdiction. But a judge also looks at the reality of where business is carried out. And this means that if business is carried out at a location separate from that of its registered office or where it is incorporated, then it is the secondary court, the court that has jurisdiction in the place where the debtor has its center of main interests. The second set of rules is that contained in Articles 14 and 15 of the Civil Code. These have been termed or called exorbitant jurisdiction. And what this means is that the French court is entitled to decide or to hear matters involving French citizens who may be litigating or transacting in a completely different jurisdiction. An example could be two French citizens in Buenos Aires in Argentina deciding on the rental of a property in that city. According to the Civil Code, a French court would be entitled to hear this matter merely because the two parties involved are French citizens. This exorbitant jurisdiction is unpopular because it means trespassing into the preserve of another court. Conflicts like this are not rare because if assets and property and litigation rights cross boundaries, then it is possible that more than one court could apply to hear the matter involved. But Articles 14 and 15 of the Civil Code will allow a French judge to determine matters involving a French debtor, even though those matters are located within the jurisdiction of another court. Whether the judge uses the provisions in the Civil Code or the Insolvency Law to determine jurisdiction, the matter remains that a foreign judgment may still need to be recognized or enforced before a French court. How is this done? Well, the answer is to be found in the procedural rules. And in the civil procedural rules, in the new Code of Civil Procedure, also known as the NCPC, the procedure is called the exequatur, and that comes from the Latin word let it be enforced. Now, the exequatur procedure is a way by which a French court examines the regularity of a foreign judgment. Now, looking at the traditional reluctance of a French court to determine matters involving overseas debtors and overseas judgments, it is easy to see that this procedure may be fairly restrictively applied, and it is in fact restrictively applied in France. What this means is that prior to the exequatur procedure being engaged, a French court will not pay any attention to a judgment emanating from another court. Now, this position has of course changed with respect to those judgments that are under the European Insolvency Regulation. In other words, judgments emanating from other member states of the European Union. But in relation to judgments emanating from elsewhere, from countries that are not covered by the European Insolvency Regulation, these rules will still apply. What this means in practice is that a judge will be called upon to apply, through the exequatur procedure, French procedure to an overseas judgment, to examine what is called its regularity. It is not supposed to be a re-examination of the litigation issues or the arguments that were made by participants prior to that judgment being ordered in the overseas court. However, in practice, a French judge will want to be assured that he can give effect to this judgment. In other words, that it is not tainted by fraud, that it was given by a court which had proper authority, and that it is the type of judgment that could have been given by that court, and a judgment that a French court can recognize. And to perform this examination or this test, the French judge has resorted to what is known as ordre public, or mandatory public order rules contained in French law. And this means that a foreign judgment which infringes these rules will not be recognized. But ones that do come into compliance with French law and with the French understanding of what a foreign judgment should be will be recognized and then can be enforced by a French court or by a French office holder acting on behalf of the court, just as a French judgment would be. So the exequatur procedure is often called the adoption or readoption of a foreign judgment into French law to give it the same effect as a French judgment. Since the European Insolvency Regulation has come into force, practice with respect to the exequatur and to ordre public rules, which do not apply in the case of judgments which fall under the European Insolvency Regulation necessarily, has changed. What this means is, because there is no exequatur procedure for judgments emanating from other member states of the European Union, then a French judge does not really examine the grounds or the basis for which that foreign court made that judgment. So there is no re-examination in substance or in procedure of a foreign judgment, as long as it is one that is entitled to be recognized and enforced under the framework of the regulation. With respect to the ordre public rules, though, things are slightly more cloudy. In some cases, the French have adhered to traditional and mandatory public order rules, particularly the preservation of creditors' interests and the promotion of employee entitlements. In others, they have not. In a signal case called Daisy Tech, which is referred to in this chapter, the French Supreme Court said that the failure to consult employees prior to insolvency proceedings being opened, in this case, they were opened in the United Kingdom, in respect of both British and French companies. And under French law, French employees should normally be consulted before such an important step is taken in the case of the company. The French Supreme Court said it was immaterial that the British office holder had not carried out that consultation. And in fact, in later cases like Mtech and Energotech, French courts have taken on some aspects of the British way of doing things and extended French insolvency procedures to subsidiaries of companies that are incorporated overseas, but which they deem to in fact be carrying out their main business in France. Under the European regulation as well, and particularly since changes to French rescue proceedings law were introduced in 2005, this dimension has radically altered the public order rules and public order concepts with respect to insolvency.